So in California, we have different types of DUIs. On a first offense DUI, there's the alcohol DUIs, and then there are the drug DUIs. And then there are the combination of alcohol and drugs. So under California Vehicle Code Section 23152A, that's an impairment charge. Okay, 23152B is being at or over a .08 alcohol. And then you've got 23152F, which is drugs. That can be illegal drugs, prescription drugs, marijuana, whether it's medical or not. Prescription drugs are often things like opiates, OxyContin, Vicodin, sleeping pills. The one that we hear a lot about is a sleeping drug called Ambien, where people tend to sleepwalk. And then G is alcohol and drugs. So we actually are seeing more and more of the F and the G. That's because more and more people, especially with marijuana, and increases in just illegal drugs and prescription drugs, are driving on those, and cops are more on the lookout for those. Basically, with the DUI drugs, what needs to be proven by the prosecution is that they need to be able to show that the driver was not able to drive like a sober person under similar circumstances due to any drug or combination of drugs and alcohol. So that's what the prosecution is trying to prove. Now, what they're basically saying is that this person is on a drug or a medication that is affecting someone's muscles, their nervous system, their brain, so that they're not functioning properly, again, driving like a sober person under similar circumstances. And that's something that, while if there's an accident or really bad driving or just someone seeming very impaired on camera, is not overly difficult for a prosecutor to prove. In many cases, it is, because someone's driving, might have been distracted driving. The field tests don't seem that bad. And also, there's no per se. In California, for alcohol, we have what's called the per se limit, and that's the .08 limit. All right. And that's, calculated through formulas and breath testing, blood testing. That's a number that prosecutors like to just latch on to, and they're a lot less likely to want to move forward or feel confidence in their case if they don't have this. Okay. So in a drug case, they need to be able to prove that someone was basically impaired. And that's why they were driving the way that they were, and that they were a danger. So how do they prove that without some per se amount in the person's system? Well, what they do is there's a lot of questioning that goes on. And then they have usually a drug recognition expert come onto the scene, typically meeting them at the police station or the jail, and doing a 12-step evaluation. Now, when you are being asked questions after you've been pulled over on suspicion of a DUI, you don't have to answer all these probative questions. Your answer to, where'd you start driving from, how much did you have to drink, were you drinking, can be something along the lines of, officer, I respectfully decline to answer that question. Once you're arrested for a DUI, then you are required to take a breath or a blood test. And if they suspect drugs, they're usually going to make you take a blood test, or if not available or there's problems doing a blood test, a urine test. But in a drug DUI case, there's a similar place where you don't have to answer questions. And that's when they bring in that drug recognition expert officer called the DRE. And the DRE does an examination, which is called a 12-step, which you can kind of figure why they call it that. It's an incriminating assumption, but they just call it the 12-step. So they made up 12 different tests that they do. They could have made it 10, 20, whatever steps, but they thought it would be better to call it 12-step. Now, when they ask you if you'll do these tests or start to do them, this is after you've done any field sobriety testing in the field and after you've been arrested, and you're at the station, wherever they're doing this, they're supposed to ask you if you will do it. But you, even if they don't ask you, you are not required to do this 12-step evaluation, which involves going through the field sobriety tests again, which involves taking your pulse, which involves checking your pupils in a dark room, checking your pulse again, looking for needle marks, asking you a lot of questions, such as what drug have you taken? They'll interview the arresting officers as part of that 12 steps and ask what you told them. They do a lot of different things. And so you are actually not required to do that. Would they call that an admission of guilt? Well, that's something, if a case goes to trial, that would be argued down the road. But really, you don't have to, and you should not cooperate with them on field sobriety testing or 12-step testing. I mean, they're going to get there. They think you're under the influence. They're going to get an amount from a blood test typically, and the less evidence that you give them, the better. This is why we say don't do the field sobriety testing. You don't have to. These tests are designed to make people fail. These tests are ones that, maybe a gymnast in their late teens, early 20s might do very well on, but you as an ordinary citizen, no matter who or what you are, under the conditions that you're in after being arrested for some type of a DUI, you're going to be nervous. You're not going to do very well on them just because of the situation, the lights, the badge, the gun, the cops, the radios, just everything makes it very difficult to do these tests, which is why I tell people, you don't have to do them, respectfully decline them. But in a drug case, in a drug DUI case or drug/alcohol, combination, which, as we said, was the 23-152 G case, they don't have that number. They don't have that per se level. There's no, say you had marijuana in your system. Give your attorney, a knowledgeable DUI attorney who knows how to fight these cases, a better chance by not doing more testing for them. You have to do certain tests. You have to do a blood test after you've been arrested for DUI. And if you don't, then they'll do a forced blood draw anyways. And so, you're not going to get away with anything there by not doing it. They're still going to take the test in most counties. But give your attorney the opportunity to win the case, to give them more evidence that you don't have to give them. Not a good idea. So these cases are hard for the prosecution to prove, a lot harder when they have less evidence, especially when the driving's not that bad. I mean, what if they pulled you over for, you didn't have your lights on because you left a lit parking lot and they got you a block or two down the street, or your tags were expired, your license plate light wasn't on, you had a headlight out, you were doing, 70 and a 55. I mean, is that enough to pull you over? Yes, it is. But is that enough to show bad driving? No. And if you don't do these tests for them, they've got a lot less give us something to work with. And unfortunately, most people watch these videos after they've been arrested for a DUI, but a lot of people watch these that are just looking for knowledge in this area and may learn something for the future or help educate others on the rules and our constitutional rights. So I hope this is helpful, and good luck to everybody.